Hey, welcome to Speechless. We are glad you're here, and we had a lot of technical difficulties today, speaking difficulties too. We're live from SPNN in St. Paul, Minnesota, and we had to redo all our graphics and videos and all kinds of things. And so running a little bit behind, was hoping to go Facebook Live, but ran out of time, didn't figure it out. So hopefully we'll be doing that on the following shows, and then you can make your comments, whatever. One thing, you know, we're only 3 blocks away from where about 260 babies were ripped apart from their mother's wombs this last week. And I bring that up because I'm going to show you some video on how the whole Constitution gets turned on its end. Of course, there's nothing in the Constitution about the right to kill your children, but there is in the Constitution the right to bear arms. Okay, so you see how that, you know, the same people that want you to kill your children don't want you to have guns. Although that is a right. Well, we're going to be discussing cameras in the courtroom. And there's a hearing in the House Committee, Public Safety Committee, and it was a bill that takes power away from the judiciary to film courtroom events, and we'll get a little bit more descriptive there. But in this whole conversation, nothing about freedom of the press. In the Minnesota Constitution, the freedom of the press shall remain inviolate. And so that means you can't diminish it, you can't, it's their press, you're free to go. And it's not happening in our courtrooms. And so you're gonna see somebody, Representative Hillstrom, try to make up rights for victims, but we don't know if they're victims yet, okay, haven't had the court case, but are then taking away the rights from the press, in particular the video press, which I am one of them. That's what I do most of, because other people tell a better story than I do, in my opinion. So today we're going to go through that hearing. Now I got 48 clips, okay? Obviously in an hour show we're not going to hear all 48 clips. So I'm going to do this show over 2 days. I just think it's that important so that you learn to understand the Constitution, learn to understand the procedures, the importance of cameras in the courtroom, what's being said against them, what's being said for them, so you have a good knowledge base. And this show will help you do that. You're not going to watch the news and get a 3-minute to 8-minute spiel, which has very little substance in it about why we should or shouldn't have cameras. This is going to be a lot of information, and you'll be able to engage and have a dialogue about it. So let's go to the public safety hearing, and it's interesting, Representative Knobloch, a Republican, is the author of this bill. Co-author is Deborah Hillstrom, a Democrat, so they're pushing this as bipartisan, and that comes up later in the hearing. And this whole hearing, except for a couple of people's testimony, was just appalling to me. I can't believe Republicans are supporting this. It's unbelievable. So let's hear the open of what Knobloch. So it's House. Well, wait a second. It's House File 3436. Okay, and what it's doing, it is taking. Right now, the Supreme Court is allowing cameras for criminal sentencing. It's also allowing cameras in civil cases if all the parties agrees, or if the judge just agrees and overrides all the parties. So it's really up to the judge in the end analysis. Now, some cases you get to film, some cases you don't. I've been able to film one case, civil case, where it's Minnesota Voters Alliance versus Steve Simon. I've tried other civil cases and have been denied. So, you know, what's the standard? You know, the emotions of the judge. So this is the bottom line. You know, you don't get a reason as to why they don't. You never know the reasons why they don't allow you to film. So this is also then, what I think this bill does right, it gives the power, the legislature is taking back the power as to who decides what gets to be filmed and what doesn't. However, the legislature is using it wrongly. Okay, so let's see the opening statement by Representative Knobloch.
Well, Mr. Chair, members of the committee, I'm here with my co-author, Representative Hillstrom, on House File 3436. As amended, House File 3436 returns our policies on having audio and video in the courtroom to what they have been for decades. That is a requirement that, absent agreement from the defendant, the victim, the prosecutor, witnesses under subpoena, and the judge, there cannot be publicly available video and audio in criminal cases.
Now, Representative Knobloch, you know, it sounds like he's going to be really good and really going to say to return to how it's always been, where the legislature writes the laws. Okay? The legislature tells the judiciary what to do. And every law is telling the judiciary what to do, okay, and how to behave and how to act and how to rule. Every law that is out there. The judiciary bases its decision off the Constitution and the statutes that are written. But here he says, well, we're returning it to all the parties need to agree before it's filmed. Well, put that in writing, okay? And you legislature, you decide, okay, you know, but here he totally glosses over the freedom of the press issue. All right, let's go to the second clip of Representative Knobloch.
This policy has served us well for decades and should be continued. To hold criminals accountable, law enforcement officers and prosecutors must have the cooperation of victims, witnesses, sometimes children, and certainly jurors. Media coverage by its nature hinders this cooperation, making it less likely that testimony that is needed is given. If reporting a crime means the world can watch a report on the 10 o'clock news or see it forever on YouTube or elsewhere, some victims and witnesses will decide it's just not worth it.
Okay, I don't know if you caught it there, but there was a bait and switch that went on. It's pretty significant. The bait and switch was, this is about videos in a courtroom. This is about a trial taking place. And all of a sudden he switched to reporting a crime. Well, you don't report crimes in a courtroom. You call the police. You call the county attorney. You know, those are who you report crimes to, particularly the police, or harassment, restraining order. You go to the judge. That has nothing. Reporting a crime has nothing to do with the courtroom. So I don't know who wrote this speech for Representative Knobloch, but he's getting played, you know, is what's happening here. Somebody's making him look bad from going from, okay, we need all parties to agree to film in a courtroom, to now we're reporting, you know, this hinders people reporting a crime because there's cameras, okay? So they're less likely to report a crime. It just doesn't make sense, okay? And really, you're really gonna be less likely? The reasons, first of all, he's got no studies on that. People report crimes all the time. There's bigger reasons they don't report crime, okay? They may be afraid, but it's not the media coverage. You know, they may be afraid of the person that's abusing them, or the crime, or the threats, or any of that, but that's not cameras in the courtroom. No, person's going to report the crime, and they're going to be glad to have the cameras, you know, if they were a victim. But again, we don't know if somebody's a victim yet. All right. Let's go to the next clip.
The courts are public. They are open. The media covers the courts daily. Defendants, witnesses, and victims can and frequently do talk to the media outside of the courtroom. But by its nature, the most media-worthy cases will also be those that are the most heartrending for victims and families. Will a young woman who has been sex trafficked want to testify about what happened and what she did, knowing her testimony will live forever on the internet, always available to a future spouse or boyfriend? Should a mother have to hear the details of her child's murder over and over again on the 10 o'clock news? What public purpose does this serve?
Okay, did you hear it again, over and over again on the 10 o'clock news? I'm sorry, stories don't last that long on the 10 o'clock news or the 6 or the 5. There may be a brief period, but they're already talking about the case beforehand, okay? The camera in the courtroom that's making the public see, and the freedom, having the freedom of the press, the camera in the courtroom does not add any more to what's already being reported, except that you get to see it, the reality. So he's saying, okay, people outside talk to the press. Okay, well, you don't know if they're telling you the truth from what happened in that courtroom. They may have misunderstood what a judge said. You know, but if the camera's in the courtroom, you get to see what the judge says. You get to see what people say, and there is no filter in between. So this over and over, this people talking outside, well, okay, they're talking inside too. So why do you restrict the press? You got no right to restrict the press. You're not accomplishing anything good by restricting the press, by not having them, and cameras, the video press, by not having them in the courtroom. So his narrative doesn't make sense. So he already admits that people are talking over and over outside in the court, you know, in the plaza or wherever, and they're already interviewing the press. They already admits that there's discussion going on in the news. I mean, that's already happening. But to say because you have cameras in the courtroom, it's going to be over and over and over again, and they'll see it for the rest of their life or be on the internet, well, yeah, it may well be. Okay, but that isn't a problem. You know, the best thing a person that's living in these type of scenarios is to expose what's going on. The person that wants to get out can get out, and the best thing for them is to speak and to be public, and in that way it destroys the lives of those that are ruining a true victim, if they're a victim at all. I mean, we see victims, so-called victims, false rape, false murders, you know. You see police officers that get to lie on the stand, that they fudge the evidence, they do all kinds of things. So many people have been wrongly convicted. And I think a big piece of that is people not being able to see what's going on in the courtroom, not being able to hear what's being said. So let's go to the next video here. And
even less salacious cases will sometimes involve people who are shyer by nature and less willing to have their words and faces publicly exposed. The primary purpose of the court is to find the truth and render judgment. Media presence in the court does nothing to help the courts fulfill this primary purpose, but has every possibility of hindering it.
You know, but he doesn't say why it has every possibility of hindering it. And actually, the primary purpose of the courts and for most judges is to run the cases through their system. They really don't care a whole lot about justice. Most of the judges have an agenda and have an outcome that they want to see and will work the case to have that outcome. That's why it's important And as we talked on the show, to see these judges. If the public saw how these judges were behaving, these people wouldn't be judges. William Leary would be gone, Kathleen Guerin. You know, you just go, what in the world did they just do? And you'll get to see these judges denying people their rights and then just making stuff up out of thin air. And by the way, that's a big thing going on. Judge Kathleen Guerin, she's totally violating the freedom of the press. She has told Dee Evervold to take down her blogs relating to her criminal charges. She has a press blog. She's trying to tell her side of the story. And you know what? The federal courts have already ruled blogging's the press, and that even though you've been convicted of a crime, you can't take away the right of the freedom of the press. And that individual to be press, you can't do that. Okay? There are other laws. They're called harassment restraining laws. Okay? So there are other laws you can use. So if somebody is personally writing letters to a person that has a harassment restraining order against them, if they're sending personal information to them and making personal threats, that's harassment, and you can be convicted of that. Telling your story as to what went on is not, and doesn't meet that category. And Kathleen Guerin is big time violating Dee Evervold's constitutional rights. So it's this narrative that Representative Knobloch is building is just kind of, it's a false narrative. It's actually just the opposite of that. All right, let's see his next one.
Please support our justice system by supporting House File 3436 as amended. And I yield to Representative Hillstrom for any comments she'd like to make.
Representative Hillstrom.
Thank you, Mr. Chair and member.
I had a bad edit on that. Please support our justice system. It's an interesting spin on what he's saying there. Supporting our justice system by not having cameras in the courtroom. Okay, well, the right of the press is in our Constitution. So by definition, cameras in the courtroom is supporting our justice system. Our justice system is not just the judges. It's all parties, and it's the public. The public is a big part of the justice system because the public elects the representatives, and we don't want to have this closed justice system, which Representative Knobloch and majority of the people on this committee are all in favor of, a closed judicial system. So you don't get to see what happens inside that courtroom. And it's too bad. I mean, see, the narrow, everything he's saying is just inside out, upside down, just the opposite of what he is saying. So let's hear what Representative Hillstrom has to say, number 6.
Members, I'm a co-author on this bill because I too have concerns about cameras in the courtroom and when it's appropriate and when it's not. But ultimately, under Minnesota law, the legislature, we pass rules and laws unless it's substantive, a substantive right to a defendant or victims, the court rule would trump state statute. And so I believe that it should be a substantive right for the defendant to waive or not, and a substantive right for the victim to waive or not. That's why I'm a co-author on this bill, and I would stand for any questions as well.
Wow, there you got it. People, you don't understand this. The courts have rules that supersede our statutes. Okay, what is wrong with that picture? But you heard it there. Now, we've heard it, we've talked about this on our show a long time in the past, and that's the reality. And so Deborah Hillstrom is trying to make a substantive right, giving the victims a substantive right. Now here's the bait and switch. Who has the substantive right? The press. It's in our Constitution. Who else has the substantive right. The public have the right to go into that courtroom and be there and to see what's happening in the courtroom. Okay? Who also has a substantive right? The accused. The accused has a right to face their accuser and to know what the charges are that they're being brought against and be able to defend themselves. Who doesn't have the substantive right? The victim. The victims don't have substantive rights. They get to go and talk to the police and the county prosecutor and the county attorney. And if the police put the package together and say, hey, you know, this is a felony, county attorney, go deal with it, you know, police do the investigation. It's up to the prosecutor who decides to whether the case goes forward or not. It's the prosecutor who has a substantive right, not the victim. Victims don't have, from what I can see, substantive rights in any of this. So Deborah Hillstrom is trying to create here a substantive right for a victim. But what's the problem with everything she's saying? We don't know if there's a victim yet. Now, the only time you know there's a victim is if there's a dead body. You know, you can go see somebody beat to a dead body may not be a victim. Another person may have been acting in self-defense. So victims are not determined until the evidence comes in. Okay, and everybody has their rights except the victim. And the only time the victim has a right is when they've been proven to be a victim through our judicial system, through through the way the courts work. So this substantive right Deborah Hillstrom is trying to create for victims is unknown. And she's saying that victim gets to determine whether that camera is shown in the courtroom or not. And that's just not true, because the people have already said freedom of the press in Minnesota shall remain inviolate. So it's not there. But let's have the legislature try to create one. All right, now we're going to have a video of the domestic violence industry talking about why they don't want cameras in the courtroom.
My name is Caroline Palmer, and I'm the Public and Legal Affairs Manager at the Minnesota Coalition Against Sexual Assault. And I'm here today to speak in support of this bill and to thank Representative Knobloch, Representative Hillstrom, and yourself, Mr. Chair, for advancing this conversation. MnCASA has followed the issue of cameras in the courtrooms for over a decade. And while we recognize there may be some limitations when it comes to criminal sexual conduct cases, our bigger concern is the public understanding of what is actually public in the courtroom. People see courtroom coverage on the TV all the time. They don't know what the rules are. Victims of sexual assault, whether adults or children who have not reported the crime, will likely not know the procedural rules that go into media coverage of a trial. And if they see if a judicial process is potentially open, or even if there's a perception of openness, victims may be less likely than ever to report the crime.
Okay, there again is this narrative. Victims less likely to report the crime, they're not familiar with the rules. You know, now here's the problem. And I mean, she's raising it in some extent that they see court cases on TV. There's some 40 states that allow whole trials to be on video and the cameras in the courtroom. Now, again, in Minnesota, there's cameras in every single courtroom anyway. They're already there, and you're being filmed. Okay, so with that narrative going on, and so a victim, she's saying a victim doesn't understand, you know, what the rules are in Minnesota. Well, you know, there's a problem, okay, because the other states have just, and national TV has just blown away your whole argument as to why to have cameras in the courtroom, because every other state's affecting how people perceive the courts to be in Minnesota. So have cameras in the courtroom. You know, this fear of reporting a crime because camera, it doesn't happen. Because a camera will be in the court, it just doesn't happen. You know, a person, you know, once they find out that there might be a camera in the courtroom, they're gonna, it's past that time. They've already said, hey, this person did this to me. That's already in the press. Person's already been accused. You know, people aren't just gonna, I just got beat up, I'm not gonna report this crime, you know, because there's a camera in the courtroom. Just, I don't, it doesn't make any sense. All right, let's go see what Carolyn Palmer says next.
I want to say that research supports this reality. Going back to 1992, the most comprehensive study of rape in this country, called Rape in America, A Report to the Nation, found that only 16% of victims ever report. And researchers identified one of their main fears in this report as media coverage. And these findings are really supported by more recent research as well. The U.S. Bureau of Justice Statistics showed in 2010 that anywhere from 15.8 to 35% of all sexual assault cases are reported. These are still very low numbers. And other noted researchers, such as Dean Kilpatrick, who's one of the leading authors of studies on victim response to the criminal justice system, has found that the fear of the system remains a high factor for victims.
The fear of the judicial system. So there's a whole lot of bait and switching going on in her statements there. 1992, do we have VCRs back then? I don't know. You know, there weren't cameras in the courtroom back then. So fear of media coverage would be it being reported. So going through the justice system or having their name, I mean, that's there anyway. But again, they're ignoring the main problem in this whole picture is that we don't know if they're a victim yet. 40% of all domestic violence allegations are false. Now that means 60% are true, okay? So maybe a big reason they don't report is because it didn't happen. They had an advantage to report it, and they may have initially reported it, but then realized, boy, if I get in there and it gets out to the public, other people are going to come and say, oh, no, that didn't happen. I was there. I know where she was. This didn't take place.
Fear of corruption of the court.
So what is the other fear that may be there? The other fear may be because they're afraid of the corruption of the court. I mean, people engaged in criminal activity or are living in these lifestyles, they understand the courts. You know, they understand how bad they could be, so they may just be afraid of the courts. So there's no reason to take away the right of the press here, none whatsoever, and that's what's being attempted here. Okay, let's go to the next clip.
Some may argue that the Me Too movement has changed this and has made reporting easier. And yeah, for some people, I think it has. But I would caution that there are many, many more victims for whom circumstances have not changed at all, and they still cannot come forward easily. Economic burdens, for example, mean that a victim cannot risk coming forward to bring their case, and they simply cannot bear the loss of income that might come with that. We've often heard and still continue to hear that victims are just seeking fame, that they're seeking publicity, that they're seeking money, that they're not believed. The stigmas and stereotypes are very pervasive. And I will say that many survivors who have spoken out have been vilified in social media, with some even receiving rape threats. So the message I think that comes back to victim survivors is that it's still not safe to come forward, and having cameras in the courtroom, I think, only is going to further the belief that there may be some risk to them.
There's that leap again. So, I mean, cameras, you couldn't, the technology wasn't there 50 years ago to have the courtroom. It's a new technology. So people back then, there's still a problem of reporting. Part of the problem of reporting is they're afraid of the police. Yeah, and they're afraid of the backlash and all this kind of stuff that could happen. None of that has to do with cameras in the courtroom. I mean, it's a long way to get to cameras in the courtroom as being the thing that determines whether somebody's going to report a crime or not. And she just said it. This Palmer, Caroline Palmer, just said it. And there's the disguise. There's the bait and switch again. There's all these obstacles along the way. Oh, and camera's going to make it worse. I mean, it's these other obstacles that are big. And it's a problem with our courts. It's a problem with our police. It's a problem with our prosecutors. It's a problem with the false accusers. And it's a problem with the people committing the crimes and putting pressure on people. There's a lot of problems going on. And you saw how our government worked in the shooting when you had 5 government agencies that knew this guy in Florida was a problem, and they did nothing. They didn't stop him. So, you know, if anything, this will help make cameras in the courtroom will make people aware of what's going on and how to deal with it, and that there is a way to deal with it. Then you better have your evidence ready. Okay. Let's go to number 10.
I really want to emphasize that MnCASA believes that an open and transparent justice system is really important. We believe that an independent media monitoring governing activities is very important too. But we also know that sexual assault victims still do not perceive the criminal justice system as a safe place for them, no matter how hard we try to ease that experience.
Wow, that was a great statement. So she again says what the problem is. Sexual assault victims don't believe the system, I forgot the exact word she said there, that the system has a problem, okay? It's not cameras in the courtroom. We want open and transparency. Well, but not in the case of sexual assault victims. The problem is the system. That's what she's saying, not cameras in courtroom. So she's speaking against herself and then trying to get rid of the cameras. It just doesn't make sense. Okay, number 11.
And I'm not talking about the criminal courts alone. Civil courts can also be an area where people are very reluctant to come for sexual harassment cases, for sexual abuse cases, and even a protective order in a domestic abuse or sexual assault situation.
You know, again, a restraining order, harassment restraining order, very easy to get, ex parte. You don't need to have evidence, and you can really ruin a person's life. If they can't fight it, or they got to go and fight it and they can't have an attorney, they're messed up. And a judges look, take these HROs very lightly, and I mean lightly, and they don't collect any evidence beforehand that justifies the HRO. They just kind of give them. Very seldom does a HRO not take place. And then when a person has a trial, you know, they delay the trials for a long time. And so the person who's been accused loses their children, can't be involved with family, and it may take a year to have the trial. It goes on in Minnesota all the time, even though they're supposed to have that trial within a very short period of time, a couple months at the most. But they keep getting postponed, and even though, so again, these short statements by the testifiers doesn't even come close to the reality of what's going on. There needs to be more thoughtful consideration by the legislature. I mean, anyway. Okay, let's go to the next video.
At the end of the day, we just cannot risk creating any further barriers for victims seeking justice. Not only are they deterred from reporting, but we as a state are losing the opportunity to hold the offenders accountable who have created the harm. If we lived in a society where victim credibility wasn't continually challenged, I wouldn't be up here today and I would be celebrating. But the fact is, it's challenged every single day. And as long as we have that skepticism and disbelief for victims in our society, at this point, we have to remain concerned about cameras in the courtroom and other media that can really influence the way victims see the system and their chances in that system. So thank you, and I'll stand for any questions.
I mean, if you understand the basics of what every person that's testifying to change this bill and to get rid of cameras, the whole purpose is to say an accusation is the truth. That's what they're doing. Let's just forget about the courts. I mean, if they can go there, that's what she was just saying on the video. If we can believe every victim, you know, then we'd have this great society. You know, well, I mean, she just totally ignores, and she knows this. I know she knows this, that people lie, okay? People will lie in order to achieve an aim, an advantage, or get things accomplished that they want to get accomplished. And they'll do it in the domestic violence industry, and a lot of times through a divorce. They can just go and say, this happened. Oh, boy. Okay, instead of having an easy divorce, now we make it harder for one party because there's an allegation of harassment or threat or bodily injury or harm when there has been none, but the allegation is all you needed. Okay, so there is no due process. That's what she's asking for. We don't want due process. We don't want to have somebody prove that they're a victim. But it's important for a person to prove that they're a victim, otherwise they're letting an innocent person be guilty. And if they prove that they're a victim, then the guilty person will be found and should be found guilty. But we have this process in this domestic violence industry, and this Caroline Palmer, they want to ignore that process. They want to just leave it alone, and people, that's trouble. And that's part of the Communist Manifesto. That's part of destroying a country, is where you can just accuse people and lock them up. And that's why we had our Revolutionary War. That's why we have our civil wars, is to stop the government from being unjust and stop people from being unjust. Okay, let's go to number 15. And this is Mark Anfinson. He's a media coordinator with the courts as part of what he does. When I go and film in courts, I got to send him a letter as to where and when and why I want to film. Not why, but where and when. So let's hear what he has to say.
Yeah, I'm Mark Anfinson. I act as general counsel to the Minnesota Newspaper Association, the trade association of all the state's newspapers. I speak in opposition to the bill. The motives of these proponents of this bill are perfectly understandable and, in fact, commendable. We have no problem with that. What we do have a problem with is the methods the proponents are proposing to achieve their goals. What you've heard so far from both the authors and the witnesses who've testified are claims almost completely divorced from current reality in Minnesota, okay? Almost completely divorced of facts. I would like to share with you a few actual facts that will give you some context for this proposal. For the last 10 years or so, the Supreme Court of Minnesota has been involved in a very slow, tortuous, laborious process to allow cameras in courtrooms to some limited extent. I've been in the middle of that because I've acted as attorney for a group of media petitioners that have sought the court's help in liberalizing camera access rules.
All right. What people don't realize, I mean, we have this freedom of the press, okay, in Minnesota. The courts know it. They're ignoring it. And so what they do, they go out and say, oh, let's study this. And so they study this. And then they go, well, yeah, everything was positive, but we need to study it more. So let's go study it more. And they keep studying it more. And so this 10 years laborious process, very slow. And we've gotten to the point right now where you can film the sentencing of somebody being convicted of a crime. So they've already been convicted, you get to film their sentencing. Of course, I think that's unjust in the aspect of you're not able to film somebody being found not guilty. You know, why can't they be filmed? That's just as important. That stands just as strong as a message. You know, yeah, film the sentencing, okay? But that's all that's allowed to film. Now, if a victim of the person who's been found guilty, they get to make a statement, and it's up to them right now as to whether they make a statement, want that statement filmed or not. Now, I was able to participate in the filming of the Grazzini-Rucki case when Sandra Grazzini was sentenced for deprivation of parental rights, assisting her daughters running away, in her mind, from an abusive father. And the father said, David Rucki said, I want to have my victim impact statement filmed. Okay, and so it was allowed to be filmed. I filmed other sentencing, one other sentencing hearing. But so that's all you get to film. You don't get the trial or anything like that. That's all you get in Minnesota. What's the big deal? How does filming a sentencing for somebody being found guilty stop? I mean, listen to what the domestic violence industry and Representative Knobloch and Hillstrom were saying about this whole thing. You know, it's like, wow, there's this terrible thing going on, and it's not. So that's the devoid of reality. Okay, let's go to the next clip, 16.
The court has conducted 2 pilot projects over that period of time to study the impact of cameras. One, a few years ago, it did in civil cases, and for the last 2 years, the court has been conducting a pilot project for criminal case proceedings. Okay? In the course of those pilot projects, the purpose of the court has been to acquire empirical information, in other words, facts, to assess not based on propagandistic claims about the impact of cameras in courts, but actually what happens when cameras are allowed.
He really hit them hard. Okay, to find and archive empirical data, scientific studies. Let's get information here, not propaganda. Not basically he was saying everything we heard is propaganda, you know, and he's right, it was propaganda, you know, but we got studies that say something different. But to me, you know, it's all irrelevant. We have a constitution. The people said, get the cameras, get the press in the courtrooms. So open them up to the public. And so you see all the twisting going on, and there's a reason they want these courtrooms closed. And the only possible reason that could be is so the judiciary and prosecutors can conduct tyranny inside that courtroom. And people, you need to rise up. You need to call Representative Knobloch. You need to call everybody on that Public Safety Committee and say, get cameras in the courtroom in all cases. I mean, these people are supporting this. They're vile people because they know what's going on in that courtroom and they're trying to cover it up. That's what's happening. And that's why these people are, to me, in my mind, some of the lowest of the low. Okay, let's go on to the next one.
And the results of the pilot projects have shown that cameras cause absolutely no discernible problems for anybody in Minnesota courts. None. There is another impact, though, that has been established as well. And that is that members of the Minnesota public, your constituents, residents of this state, have for the first time in the state's history been able to see what actually occurs in courtrooms. which, if you know about that, is normally pretty impressive, but until a few years ago is completely barred to the public.
I tell you that was a fantastic statement there. And he says no discernible problems. Okay, that means we don't know what the problems are, or that there are any problems. There's nothing that's been discerned that a problem happened because there was a camera in this courtroom. But he goes, people now see what occurs. And I would encourage all people to go down and take time and go and sit in a courtroom and watch what's going on. And I have a lot of people that have now done this, and you know, they're kind of appalled what happens in a courtroom. But on the other hand, they're also, wow, this is really interesting. What took place? What happened? Why was this said? Why was that done? Why did this judge do this? What's going on? This doesn't seem right. This seems right. You know, and the education and the learning that's taking place is really, really valuable. And go down and sit when these DUI drivers, you know, are settle and plead out their terms. You know, you'll learn a lot about what's really taking place. And these legislatures need to go see, because when they're writing these laws, they haven't been in a courtroom. They haven't been in hardly any courtrooms, if at all, except you have some prosecutors on this committee and you have some attorneys that may have been in courtrooms. Depends on what the role is as an attorney. So with no discernible problems by what they've done so far, what's wrong with having a camera in the courtroom? And the answer is nothing, and it benefits the public. All right, let's go next.
And in particular, in criminal cases, the cases that typically concern the public the most, for good reason, members of the public have been able to see people who commit terrible crimes that have caused great concern among the public generally, brought before the bar of justice and sentenced for what they did.
So is it a deterrent to having these? You see people sentenced. Is it a deterrent? It wakes people up to saying, do I really want to go through this? Is this something I want to do, you know, before I commit this crime, you know, because this could happen to me, you know? So the video sentencing serves a public good when somebody's been convicted of a crime, that they get to see what took place, that the public got to see it, they got to see the actual event and the trauma it caused. Is it a deterrent? It may or may not be. I don't think it's matters whether it's a deterrent or not. What I think matters, though, is that it's public, it's open, people got to see it, and people get to determine whether this was a right thing to do or not, and then therefore they can redo the laws or base their laws based on actual seeing what took place. All right, next video.
Now, all this talk about victim concern and exposure of the justice system to this terrible pestilence of cameras has, again, no basis in reality. I'm going to tell you a few points briefly. And Mr. Chair, I respect the committee's time, but this is an important issue. Let me tell you two more things to conclude my testimony. One, what the current Supreme Court rule governing cameras in courtrooms actually says, what it allows and doesn't allow, which is as follows. This is the current Supreme Court rule that allows cameras in criminal proceedings, the focus of this bill, okay? The only portion of a criminal case that can be captured on camera, audio or video, is the portion of the proceeding that occurs after a guilty plea has been obtained. None of the testimony of victims, none of the testimony of witnesses, none of the proceedings in the court during the trial are public. I'm sorry, can be captured on video or audio. Only when the defendant is going to be sentenced can cameras come into the courtroom. And that's it. Okay? No audio or video coverage is permitted at all when the jury is present in the courtroom. None. No coverage of any kind is allowed in a proceeding held in what they call problem-solving courts, which are the specialized courts that deal with drugs, mental health, veterans, and DWI. No coverage at all under the current court rule. No coverage whatsoever is permitted in cases involving charges of criminal sexual conduct or in cases involving family or domestic violence. No coverage.
All right. But remember, there's this slow creep, okay? And so these legislators are jumping on this aspect that, boy, the courts may start expanding the role of cameras in the courtroom. And so they don't want this to happen at all. And so even though it's only for a sentencing and then some civil cases, like, you know, Minnesota Voters Alliance versus Steve Simon. Well, you got all kinds of professionals there. The state attorney, highly professional attorney, Eric Cardle, Minnesota Voters Alliance, a reputable organization. You got a judge that's getting paid $120,000+ a year. So these are professionals, okay? There's no reason in these civil cases not to have cameras in there. And the same way in criminal cases too, okay? These are professionals. They know what they're doing, okay? You don't know what they're doing. That's why there should be a camera in that courtroom. Okay, let's go to the next video.
And no audio or video coverage of any kind is permitted of a testifying victim unless the victim affirmatively acknowledges in writing before testifying to the coverage. That's the current court rule.
And that victim testifying is during sentencing. That's the current rule. That's all he was explaining there. This is how it is now. And so you have this extreme overreaction that you can actually film sentencing. Well, you know, what's kind of happening, I think part of what's happening is these legislatures are getting feedback that the sentencing happened, but boy, that sentencing wasn't right. Shouldn't have happened that way. And so you see judges doing it, like in the Sandra Gazzini-Rucki case, let's just throw out the rules, okay, and let's just do something different, and totally go AWOL as far as following any of the procedures or processes. So, I mean, attorneys would see that and say, boy, we can't have this on TV. You know, this makes us look bad and this makes the court look bad. I mean, if you knew what the laws were and you see somebody get sentenced to having to go to jail 15 days for the next 6 years, just for 15 days, I mean, that doesn't happen. And that got reversed in the appellate court. So, you know, people get to see how bad it is. Okay, let's go to the next video.
So what you end up with in current criminal proceedings in Minnesota under the Supreme Court's pilot project rule is that defendants who have committed terrible crimes and who are being sentenced by the court get to be shown on television or on a website of a newspaper. And the question I have for the committee and the proponents of this bill is, why is that a bad thing? What is wrong with allowing people to see a court sentence of a person who's committed a terrible crime? It's baffling to me. We're not talking here about any victims being shown, any witnesses who don't want to be shown, any portion of the trial, only that little final segment of a criminal case.
Why is it a bad thing for that little segment? And so Mark Anfinson is trying to hold on to so that gets to be shown. And there is no reason for it not to be shown, but he's trying to hold on to say, hey, let's at least do this. Now, legislature, you go and approve this. I mean, this is what I would say. You have the right, you have the power over the judiciary. You write the laws. You tell the judiciary what to do. Okay, and if you say cameras in the courtroom, guess what? Cameras are in the courtroom, as it is in 40 other states. But just to hang on to this thread, that's what he's trying to do there. Okay, next video. Let's try to get 2 more before we got to go here. Number 22. All right, let's go.
One final point. As I said at the outset, I think it's important here as we look at an issue like this that we focus on facts, not on propaganda, okay? Not on speculative claims that are not connected to reality. Minnesota has tiptoed along the path of cameras in courts now for almost 10 years. No problems have been identified, but it's still a tentative experiment. What isn't tentative is the fact that approximately 40 other states in America have routinely allowed camera coverage in all civil and criminal proceedings for 30 years. Okay? Wisconsin, North Dakota, Iowa have allowed almost unrestricted camera coverage of civil and criminal cases from beginning to end for 30 years. When the Supreme Court was considering this issue several years ago and establishing the pilot, we had a prosecutor come over from Wisconsin, a criminal prosecutor, and he testified in favor of Minnesota liberalizing its camera rules. And he was challenged very vigorously by the Supreme Court's advisory committee. And at one point in his testimony, he leaned back and he said, "Folks, quit looking for the boogeyman. There is no boogeyman with cameras." This was a criminal prosecutor from.
Yeah, there is no boogeyman. All right, we got to go. We heard the main testimonies. Next week, we're going to go into a lot of bantering back and forth on this issue. You'll find it fascinating to hear and see what's being taken place. So remember, if you don't stand up for other people's liberties, who's going to stand up for yours? And good men don't do nothing. The fireworks start next week on this cameras in the courtroom. God bless.